It's time to join Montana's very own and your voice for agriculture, Talkin' Ag Lane Nordland, for today's LaneCast.
Hello, everyone, and welcome to more conversations here on the LaneCast Ag Podcast in partnership with the Western Ag Network. And for many months, since October 2022, farmers, ranchers, landowners, builders, and so many different stakeholders have been awaiting the Supreme Court's decision after they heard those oral arguments last fall in the Sackett versus EPA case. And finally, on the morning of May 25th, the High Court ruled that the Environmental Protection Agency cannot get away with what it wants to do, essentially. And of course, this has been quite a case that has been followed for several years. The Sackett family hailing from Idaho, but I'm just a farm broadcaster. I'm not a legal scholar, but joining us here today from Washington, D.C. is the National Cattlemen's Beef Association's Chief Counsel, Mary Thomas Hart. And Mary Thomas, obviously, the High Court ruled in favor of the Sacketts, reversing that Ninth Circuit Appeals Court decision. Obviously, we'll go through the history of what the Sackett versus EPA case is, what it means going forward. But what does this mean to the cattlemen and women that have played a big role in the legal proceedings and having a voice in this, what many call overreach by the federal government?
Well, first, Lane, thank you so much for having me. And, for a farm broadcaster, I think you're making a pretty good legal expert. You've given a pretty good summary and definitely asking the right questions. I think today, farmers, ranchers, cattle producers, landowners across the country are experiencing a massive exhale. At least that's how I feel in my office. This is an issue that we've been working on pretty directly since 2015, whether it was through the administrative regulatory process, through litigation. But I know for many producers across the country, they've dealt with different iterations of a WOTUS definition since the Clean Water Act was passed into law in 1972. So, this is a huge moment in creating as much clarity as possible for landowners across the country. And I think, the death of the significant nexus test is not something that we're taking lightly. We are certainly happy to see it go away.
Now, obviously, this was a 9-0 ruling. So all the justices agreed that obviously the scope of the waters of the U.S. under the Clean Water Act was outside of its true scope. And I guess when we go through these opinions, there's actually differing opinions from the justices. What does that look like? Obviously, there is over 80 pages in this opinion, and I know you finally had time to go through these as well. But when we go through the opinions, what should our audience know? What came out of the decision today?
So a couple takeaways, and I think, high level, first of all, we got two unanimous holdings from this court. One, applied to the facts of the case, the Sacketts are not liable under the Clean Water Act. Their wetlands are not federally jurisdictional, and every justice on the bench agreed to that. The second thing that was unanimously agreed upon is that the significant nexus test is not the standard that EPA and the Army Corps of Engineers should use in determining if a feature is jurisdictional under the Clean Water Act. Two massive holdings, both of which were 9-0 votes. Now, when we get into, what to use instead of significant nexus, that's where we see some differentiation. I think it's important to highlight, the last time we kind of got into this mess over what test to use, that really got us to where we are today was in the U.S. Supreme Court's Rapanos case. And that was a 4-1-4 decision where we had four justices recommending a continuous surface connection test, one justice recommending the significant nexus test, and then four justices saying, we don't really like either of these, but significant nexus is the lesser of the two evils. And that's how we got into this. I think like 15, nearly, 20-year kind of back and forth over which standard to use. The court, even though it was divided in which test to use in determining jurisdiction under the Clean Water Act, I think was incredibly mindful of that. So the majority 5 of the justices recommended the continuous surface connection test as the new standard for defining which features are federally jurisdictional. The 4 justices in the minority said, we don't love the continuous surface connection test, but we also don't like the significant nexus test. So they didn't provide an alternative test. So continuous surface connection is going to be the law of the land. That's going to be the standard that the EPA and Army Corps of Engineers are tied to for future definitions of waters of the U.S.
Now, Mary Thomas, obviously, when we talk about that connection point, there's been a lot of concern from farmers, ranchers, landowners over the years about, again, what is navigable. So sometimes we do have water that is coming through an area during a rainy season, or we have a really good snowpack. Obviously, is that still up in the air on a time length of what is navigable and how that connects, or is that something that legal minds are going to be arguing going forward, since they truly didn't make a full decision on that aspect of it?
Right. So continuous surface connection, I think, is a pretty narrow standard, right? And EPA is certainly going to be tasked with defining what is a continuous surface connection. But continuous doesn't give you a lot of wiggle room. When NCBA looks at any definition, we're really looking for 3 things. And I think 2 of those were pretty clearly addressed in today's opinion. The first is the regulation of isolated features, isolated wetlands, isolated, whether you're talking about prairie potholes, vernal pools, playa lakes, those features that are not on their own connected to a downstream navigable water. I think that based on today's opinion, those features are clearly not going to be subject to federal jurisdiction in the future. Now, the other feature that we are, always mindful of are those ephemeral features, or features that really only carry water after a precipitation event. And that's where the word continuous is going to come into play, because there are 3 different types of, streams or categories of flow. So perennial, year-round, all the time, those features are generally subject to jurisdiction, and people don't really argue over whether those features should be managed by EPA. Seasonal features or intermittent features, I think, is going to be the gray area. And that's where there's going to be a lot of conversation about, if something flows for a few months a year, for one season out of the year, is that enough to consider it continuous? That's a question that we'll have to answer in the future. But I think when it comes to those ephemeral features that really only carry water after sporadic precipitation events, it's going to be a pretty clear no from the Supreme Court on federal jurisdiction of those features. So, maybe still a couple questions to answer, but I think, someone said earlier today that we've moved the scrimmage line. And I think that's a really good analogy. It certainly changes our starting point in a future conversation with EPA about which features are in and which features are out.
Now, maybe backtracking just a bit here, as I mentioned earlier, the Sacketts themselves were trying to build a house.
Mm-hmm.
And again, farmers, ranchers also got in on this litigation too, to support them in their legal efforts. Can you just share a little bit on the history of the Sacketts and their legal endeavors that have taken them all the way to the U.S. Supreme Court? This isn't something that has just popped up in the last 1 or 2 years. This has been a multi-year legal battle for property rights.
Absolutely. It has been a multi-year back and forth. And this is also the Sackett's second trip to the Supreme Court concerning this one plot of land. So quite a while back, the Sacketts bought a piece of lakeside property to build their dream home, as we all aspire to do one day. And the plot in question is near an already developed area. So, they purchased the land, started to do some prep work, and then were approached by the Army Corps of Engineers and EPA saying that they needed to obtain a Clean Water Act permit before dredging and filling wetlands that were on that property. So their question to the Supreme Court, that they've, gone to the Supreme Court related to kind of other more practical matters in the permitting process, but then had the opportunity to take this question to the Supreme Court of whether their wetland specifically on their property were jurisdictional waters of the U.S. And because there's not a continuous surface connection from their property to Priest Lake, which is what the court considers a traditional navigable water, then their land is not subject to federal permitting requirements. But you're absolutely right, Lane, that there has been quite a bit of litigation over this one piece of land and a lot of time spent for the Sacketts to hopefully now be able to build a house on the land that they purchased.
They'll probably be having one heck of a barbecue get together once that house is built next to the lake with this decision.
Yeah.
But as we go forward, though, obviously, Mary Thomas, we've seen so many presidential items on waters of the U.S. We saw the 2015 WOTUS rule put forward by the Obama administration. Then we saw the repeal of that by the Trump administration and the replacement of the rule with the Navigable Waters Protection Rule. And then the Biden administration comes in, repeals the Trump rule, and puts forward their own WOTUS rule. Now, that was done pretty quietly at the end of last year. How does this impact the Biden WOTUS rule going forward? I know that's a lot of questions we've been seeing online and on Twitter just in the few hours since the opinion from the high court came down. What is the next steps? And again, a lot of people thought that the Biden rule was a little too hasty. A lot of people, including the NCBA, asked that rule not be put forward until the high court ruled. But I guess that's the question. What does the Biden rule look like now?
Those are some great questions, and questions that the court addressed in their opinion today. So, while for the last 8 years we've been fighting over regulatory definitions of WOTUS, the Supreme Court's kind of been in the background, right? They haven't had a WOTUS case in quite a few years, but they were clearly watching what was happening. And I think they were clearly very concerned about the administrative kind of flip-flopping and whiplash that we saw from EPA in the last few years. And so I do think that one of the purposes of today's opinion and the very clear holding was to kind of reinforce the EPA, look, regardless of what our standard is, we don't have time, and regulated stakeholders don't have time for the regulatory whiplash that's being created by these, various definitions of WOTUS. So when it comes to the Biden rule that is currently in effect in 24 states, I think at a minimum, the Biden administration is going to be required to pull that rule back and do some very significant revisions. The significant nexus test is the cornerstone of this rule that was finalized a couple months ago. And so with the significant nexus test gone, that kind of pulls the underpinning of everything in that definition. We will likely work in the federal district court system to ask for a vacatur of that rule. In the meantime, NCBA is currently involved in litigation fighting the Biden rule, so would be able to, work through that process in fairly short order. But that's more, I think, of a procedural matter, right? So in practice right now, if you're operating or if you're considering the need for a 404 permit, while that rule is still theoretically in effect in 24 states, I doubt we'll see EPA or the Army Corps of Engineers utilizing the significant nexus test in those jurisdictional determinations going forward from today, just because they've gotten that ruling from the Supreme Court, and they know that anything they do when they're following the significant nexus test now is going to be pretty vulnerable.
And I know this week, obviously, the injunctions came from two different lawsuits, or were granted in different states. Obviously, Texas and Idaho grouped together, and then a court in North Dakota, which granted an injunction on the Biden rule. But I saw earlier this week that the EPA filed a request in one of the court, is it the 5th District down in New Orleans, to vacate that decision for Texas and Idaho. Obviously, that probably won't get vacated, or will they just, will that lower court just throw that request out the window?
EPA has been fighting I would say harder in this case than they have in the past, right? They have been more aggressive in this series of litigation on the Biden rule than they were in either the Trump or Obama litigation, which was quite surprising to us. And I think, to an earlier point you made, we were really surprised that they chose to finalize this rule before the Supreme Court issued its opinion. One of our primary arguments against finalizing a rule early is that you're using limited resources to finalize a rule that's likely going to have to, get some revisions. And EPA didn't listen. And so I think they are putting a lot of time and resources into defending a rule that now, the Supreme Court has ruled is clearly not the law of the land. It is going to have to be pulled back. So yeah, I foresee that action from EPA kind of winding back, because they really do have to take things back to the office and kind of figure out if they can rewrite this rule in a way that works, or if they're going to have to start with a clean slate.
Now, also, as we mentioned, the Sacketts have been following this legal path for several years, and it's a costly affair to do. And of course, agriculture groups, building groups have jumped on to help in this legal quest as well. Could you maybe just paint a picture for our viewers and our listeners on how livestock and agriculture groups like NCBA can come in and help in these legal efforts and really help get a decision that is favorable for landowners, farmers, and ranchers? Again, this was not done overnight. It wasn't done with just one party, but the decision by that one family to continue to go up against federal regulations, they could have thrown in the towel early, but they didn't. Can you just share how that works and how different parties can be involved in a case like this?
Yeah, you're absolutely right. And I think from NCBA's perspective, this is an issue that we've been working on for years, utilizing all three branches of government to do it. And I think, that's an important, kind of unique piece that we're able to bring to the table, right? We lobby Congress, we work with EPA, but then when necessary, we also go to court. And so that's what we've done with the previous three regulatory definitions. But when there are these private causes of action, when there is a family out there or an operation that wants to, push back on EPA, we certainly provide the assist, especially when we get up to the Supreme Court. And I want to give the Pacific Legal Foundation credit here. They, have represented the Sacketts from the beginning. So, I think, their work and expertise has been incredibly valuable to the Sackett family. But when we get up to the Supreme Court, a lot of people step in to make sure that those arguments made by the Sacketts are as robust as possible, whether it's from ag groups or building groups or other industry, other landowning entities. We want to make sure that those justices see just how broad the impact of something like the significant nexus test can be, right? It's not just this one family. It's not just this one wetland. It is across the country, impacting small businesses, family operations, farmers and ranchers. So we, I think work together really well with other groups and other industries. And then obviously, parties in litigation to make sure that we are conveying the breadth of the issue to whoever is on the court.
In other areas, Mary Thomas, that are very important for cattlemen and women, what else is on your desk here as of late that folks should be aware of, and that maybe is stuff taking place behind the scenes before maybe it even gets out there, trying to prevent anything from impacting the nation's livestock industry? Can you just share on some of the other matters that NCBA legally has been working on or continues to work on, or other achievements we've seen over the past few months?
There's always plenty to talk about. And I'm just, I'm really focused on our environmental issues. So I'll maybe just provide some highlights there, but always know that, whatever I'm working on or talking about, compound it by quite a few. And that is, what all we're working on in this office and what all we're fighting back on. So just in my space, I think, hopefully this decision goes a long way in settling the WOTUS argument and putting that to bed. I think the next question is going to be related to the regulation of groundwater under the Clean Water Act. There was actually an opinion from the Supreme Court a couple of years ago that kind of leans into there being a bit more jurisdiction over groundwater under the Clean Water Act. And EPA really has yet to tease that out. So as they go through that process, we'll be very engaged, especially on behalf of our small and medium animal feeding operations that may or may not need Clean Water Act permits at the moment. Also, always engaged on the climate front to make sure that livestock production, including all segments of U.S. cattle production, are considered a climate smart practice, and that we have access to USDA climate smart agriculture programs, that we continue to have access to low interest credit, and other considerations related to the climate impact of our industry, and really highlighting the value of U.S. cattle production, especially compared to other beef supply chains around the world. One other thing that I would highlight is in the species space. So this is litigation related. We've litigated on NEPA, the ESA, the Trump ESA rules, and we're currently in litigation against the Fish and Wildlife Service on the listing of the lesser prairie chicken in the middle of the country. So always active, like I said earlier, across all three branches of government, making sure that we are, in every space to defend and advance our policy priorities.
Again, Mary Thomas Hart, Chief Legal Counsel there at the NCBA Washington, D.C. office. We got through a lot there in just under 20 minutes, Mary Thomas. Hey, anything else that you would just like to share with our listeners and viewers here today before I let you get back to that busy day out in D.C. and talking to other farm broadcasters and reporters out there on this very important topic for rural America?
I think I'd highlight that, we got a really big opinion today. There's a lot in there. We're still reading through it. And to stay informed as we're kind of working through the process, whether it be at EPA or in the court system, you can go to policy.ncba.org. Policy.ncba.org to follow this issue and all of the issues that we're working on.
Well, again, thank you so much. And as we said before, Sackett versus EPA, the U.S. Supreme Court has ruled in favor of that Idaho family. And that decision is going to have a big impact on farmers, ranchers, landowners, and so many others out in the countryside from government regulation. Again, Mary Thomas Hart, thank you so much for joining us.
Thank you, Lane.
All right, friends, that will do it for today with this important news update. I'm Lane Nordlund. We'll catch you next time.
Thank you for tuning in to the LaneCast with Talkin' Ag, Lane Nordlund. For more on Lane, check out his Facebook page, Lane Nordlund Ag Broadcaster, and NordlundCommunications.com. Don't forget to subscribe to the LaneCast on your Apple or Android devices. We look forward to joining you next time on the LaneCast.